Okay, so imagine this. An election gets decided by hundreds of votes that seem completely, obviously illegal. Or were they? Today, we're diving into a wild homeowners association dispute that all came down to a legal loophole so small it was literally hidden in just 2 words. And that's really the big question here, isn't it? If you believed your community's election was totally swung by a huge block of fraudulent votes, you'd fight it. Of course you would. But what happens when the rules aren't nearly as black and white as you thought? And we're not talking about a handful of questionable ballots here. We're talking about 207 votes. Now, in a typical HOA election, that is more than enough to completely change the outcome. This one number, this is what the whole fight was about. All right, so let's set the scene. The date is March 29th, 2019. We're in Arizona at the Vistoso Community Association, and they're holding an election for their board of directors. And trust me, things were tense, and the results were about to kick off a major dispute. So here's what went down. 2 big developers, Vistoso Highlands and Pulte, owned 207 empty, undeveloped lots in this community. And when it came time to vote, they cast all 207 of their votes for one single slate of candidates, which, as you can imagine, basically decided the entire election right then and there. Well, this just did not sit right with one particular homeowner, a guy named Paul Moffett. He looked at what happened, he cracked open the community's official rulebook, the CC&Rs, and he was convinced a huge rule had been broken. So he took action and filed a petition to challenge the election results. On the surface, Moffett's case looked like a total slam dunk. It was incredibly simple. On one side, you've got the rule, right there in the official documents. If you're a member paying a reduced fee, you are not allowed to vote. Period. On the other side, you've got the cold, hard fact, both of those developers were paying reduced fees on their lots. I mean, looking at that, it seems pretty straightforward, doesn't it? The rule says one thing, the developers did the opposite. Their votes shouldn't have counted, the election should be overturned, case closed, right? Well, not so fast, because the HOA, they had a surprising counter-argument, and their entire defense, the whole thing, hinged on 2 tiny words, buried deep inside that very rule. And this is where a simple case gets really complicated. Here it is. This is the whole ball game. See, the rule didn't just say members paying a reduced fee couldn't vote. It said members paying a reduced fee pursuant to Section 8.3 couldn't vote. Those 2 little words, pursuant to, which basically just means in accordance with, changed everything. So what in the world was Section 8.3? Well, you can think of it as a temporary discount pass for developers. It was a clause that let them pay lower fees, but, and this is key, only for a maximum of 2 years after they first bought the properties. And this timeline, this is the heart of the HOA's entire argument. Just look at these dates. One developer's discount period expired way back in 2009. The others expired in 2016. But the election didn't happen until 2019, years after both of their legal rights to that specific discount were long gone. And that is the loophole in a nutshell. So yes, the developers were paying less, that was true. But because their official discount period under Section 8.3 had expired, they were technically no longer paying those reduced fees pursuant to that section. They were just being underbilled. Their discount wasn't the specific kind of discount that the voting ban was talking about. So all of this legal hair-splitting, this whole argument about 2 words, it ends up in front of an administrative law judge. How on earth would the court rule on such a tiny technical point of language? And there you have it, straight from the judge's decision. The judge sided completely with the HOA's defense. The logic was just brutally literal. Since the developer's discount wasn't technically in accordance with Section 8.3, the voting ban from Section 7.3.1 simply did not apply to them. So the final outcome was crystal clear. The judge ruled that all 207 of those votes were valid, Paul Moffett's petition was dismissed, and the original election results stood. That 2-word loophole held up in court. Okay, so you might be thinking, that's a crazy story about one HOA in Arizona, but why does it matter to me? Well, because the lesson here is universal for anyone who lives in a community with any kind of rulebook. It's about the incredible power that can be hidden in the fine print. So what can we learn from all this? First and foremost, every single word in a legal document matters. A lot. Second, A so-called technicality can be way more powerful than what seems fair or what you think the spirit of the law is. In court, it's the strict, literal reading that wins. And finally, it's a huge reminder to always read the fine print, because the devil really is in the details. And that really brings us to the final question, the one for you to think about. This entire case was decided by two words that a homeowner and probably most of his neighbors completely overlooked. It just makes you wonder, doesn't it? What tiny, powerful little phrases might be hiding in your own community's rules, just waiting for the right moment to change everything.